Hello, this is Matt on the Moon Family Sedan channel. Attorney John Deaton shares what he says is the best update ever pertaining to the SEC v. Ripple case. That's a direct quote. Best update ever. Quote from Attorney John Deaton. And also, he jumped into some community discussion having to do with the SEC v. Ripple lawsuit. I want to share with you some of his new comments because he outlines the reason that he says it's absolutely possible that Ripple could end up with an outright win, which is also a quote. He thinks it's possible that Judge Torres rules in favor of Ripple and that there is literally an outright win. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so here's the headline from the Crypto Basic. Ripple v. SEC lawsuit gets the best update ever. And this is what was being referenced. It's actually kind of just funny. So, XRP community member and attorney James K. Filan, I'm sure many of you, most of you probably are aware that he's gone to great lengths over the past couple years to share updates in terms of the scheduling for each step of the case. And now we're at a point that as of January 19th, there's nothing left. So here's the latest scheduling update, and he simply wrote scheduling update as of January 19th, 2023, and shared this screen grab from what looks like a Microsoft Word document. And he just wrote, everything is briefed, now we wait. And then in small font, he wrote, patiently. So it's over. So just to highlight, and this is exciting because I'm still optimistic. I mean, we could get a better ruling, but I'm very optimistic we're going to get a good ruling as XRP holders, even if Ripple technically loses. As long as we got a path forward for XRP, I'm not going to care that much. I'm not going to cry. I'm not Ripple. I just want XRP to continue to be able to exist in the United States. But we're in the home stretch here. We really are. Everything's briefed. We're going to find out soon. Even if we still have to wait X number of months, the ruling's coming. We're going to find out. And again, I'm optimistic, so that's a big part of the reason that I'm excited. And I can only imagine the day we get good news, assuming that happens, what's that going to do for the price of XRP? I think it's just going to go ballistic. To what degree, I don't pretend to know, but if we really are at the beginning phases of a bull market, and we get this news, rather than happening last year during a bear market, whew, I can only imagine. So we'll see. And so attorney John Deaton retweeted that and said, the best update ever. Indeed. And attorney Jeremy Hogan responded and said, thank you, Jim, for everything. Now we wait indeed. Now there's a broader XRP community discussion that was going on having to do with just people sharing ideas in terms of what is most probable to happen in terms of the outcome of this case. And talking about some recent comments from Ripple CEO Brad Garlinghouse, and he shared that he thinks that there's about a 0% chance of settlement occurring. Well, XRP community member and attorney Bill Morgan had the following to say, which is what kicked off this conversation, which ultimately led to attorney John Deaton jumping in as well. But Bill Morgan said, just my opinion, but Brad Garlinghouse saying the matter will go to a judgment and saying he is confident on the law and the facts does not mean it will not settle before Judge Torres decides the summary judgment motions. What should he say? Our case is weak, or we need to settle? Give me a break. Brad is posturing, keeping pressure on the SEC. I had a trial this week that settled halfway through day one. That half day involved an initial appearance before the judge to tell him the parties were talking and having a recess and a further appearance to tell him it's settled. I often attend mediations in which a party says there is no way this matter will settle, only for it to settle. Matters often look like the dispute is intractable and won't settle until it settles. Yeah, so I think that's a perfectly fair and reasonable thing to assert, and I acknowledge it's possible for settlement. It's just with each passing day, I am that much less convinced. So if I have to bet right now, will there be settlement? My bet at this stage in the game is no. But it could. I'm not pretending like it couldn't. That's my bet, my for fun bet. Now, XRP community member Jay retweeted that and wrote the following. There's no way the SEC can settle and give the okay to Ripple to allow them to continue their current business model. Just think about the influx of companies and startups that would follow Ripple's exact business strategy. There's no way to settle in Ripple's favor. New crypto projects would be popping up all over the place, even existing companies. If all you have to do is create a token under one entity, gift it to yourself under a different entity, then sell it and profit from it, man, that's a whole world of new problems. And look, I think that's actually a fair critique years ago, before the SEC v. Ripple lawsuit. So specifically in 2019, this might have been the first time that I publicly brought this up. Probably was. On my channel, I stated, now look, I don't think XRP is a security, of course, but I stated even back then, and I had way less understanding, of course, of the legal nature of like the Howey test and this or that. I had much less of an understanding, but it struck me that if you could get around securities laws simply by creating a thing, creating a token, and then just using that in a way that actually, now I would word it as satisfying how, if you could just, but again, if you could just launch that coin, and then you create the company, and then somehow it's not it's not in any sort of violation purely because of that. I'm like, I don't think that the government's going to allow such a loophole to exist. Now, of course, I have a greater understanding of the Howey test and everything now, and so the reason that a lot of those types of things could have legal trouble is if there is a common enterprise. And I mean, there's certainly, we've been talking about, is there an ICO, stuff like that. But that in and of itself, that doesn't mean that the cryptocurrency is damned forever. It also doesn't mean that. So like XRP today, obviously, with it being completely decentralized, no, clearly not. Of course, it's not a security. It itself certainly is not a security. And current transactions, I don't know how they could be either, with the decentralized nature of XRP and the XRP ledger. So, but that's why we don't have sufficient regulatory clarity from the SEC, and that's why this whole thing's so messy. That's why we're having this conversation. But yeah, I remember even stating that back in 2019, and I was like, I hope that people listening to me don't crucify me for pointing that out, because that is my open, honest opinion, and everybody was really nice and respectful, whether they disagreed or agreed. But I did state that back in 2019. I was like, is what it is, but still. And so then XRP community member Stefan Huber jumped in and quoted JV in the part where he said, if all you have to do is create a product and then sell it and profit from it, man, that's a whole world of new problems, end quote. Stefan Huber then said, just replace token with product, and you will see that this would not be a problem at all. No one is forced to buy a token/product. And that's certainly also true. When a cryptocurrency is created, it's worth exactly $0.00. And so if an ecosystem ends up popping up around that for any number of reasons, okay, but that still doesn't mean that the token itself, by the nature of existing, is a security. And so Jay responded to that and said, let's take Apple for the sake of your example. Before they went public and became established, if Apple created a capped amount of iPhones, 100 million, used the profits from the sales of those iPhones as revenue to build up Apple, and promised efforts to get it adopted and raise its value, while putting 50 million of those iPhones on the market to be traded on by investors, while Apple sell on that same market for its revenue. Do you all honestly believe that would be okay? Or are you going to continue to try to make excuses and comparisons due to your biases and create examples while leaving out certain aspects surrounding Ripple and XRP? Like I said, a settlement that allows Ripple to carry on with no changes opens up a new world of problems. And so I'm not so sure that it does, though, because and just respectfully, it's perfectly fine that Jay's sharing his opinion. So this is not against him whatsoever. I think it's totally fair what he's saying. I personally don't see why it wouldn't necessarily be the case that Ripple could continue on with conducting business as they are, especially if there's a favorable ruling. I mean, think about this. Even the SEC, throughout all of this, never sought to stop Ripple's sales of XRP. Even the SEC isn't trying to do that. And so Stefan Huber responded to that and said, so you're saying XRP is a security and should be regulated that way? And then Jay responded to that and said, I'm saying Ripple's transactions are. I can't think of how they will get around it. Also, another reason why I'm convinced they'll lose is notice how they really didn't put up a good argument about anything but the blue sky laws on whether an actual contract is needed or not. So let me pause right there. As far as the blue sky laws, I'm going to let Attorney Deaton speak on that because he does have something to say on that, and I believe it's in the thread I'm going to pull up in just a second here. As far as Ripple's transactions, him saying that they are securities transactions, I respectfully disagree on that. Like, there may be an argument to be made, a compelling one perhaps even, perhaps, that certain transactions in the earlier days, that would be easier to satisfy. But if you're talking about a cryptocurrency where, the SEC can't even identify what the hell the common enterprise is, which is the case here, I don't see how transactions today could possibly be viewed as securities transactions. Like, we're all in, what, are we all in a common enterprise together? Like, you listening are in a common enterprise with me if you hold XRP, and I'm in a common enterprise with Jay and John Deaton and everybody else. I don't think so. I don't think that makes any damn sense. What you're talking about is an entire ecosystem, which is why I pointed out the other day, if you're talking about the gold ecosystem, can you imagine that if the SEC's assertion was that miners of gold were in a common enterprise, not just a common interest, but they have a common enterprise with jewelers or companies that use gold and electronics products? Is that a common enterprise? I don't think so. So when you're looking at Ripple's transactions, they're just forever and always, no matter the changing of the ecosystem, they're always illegal securities transactions? I don't think so. So I just respectfully disagree with Jay on that particular point, but we're all entitled to our opinion. Perfectly reasonable for him to say that. I just disagree. And then there's this from attorney John Deaton. Now check this out. He says, here is how the judge could give Ripple an outright win. People are focusing on the pre-1933 blue sky argument. That argument is for the Second Circuit and Supreme Court. I don't believe Judge Torres agrees with that argument, although the Supreme Court could. I'm not saying this will happen. I'm just addressing Jay's concerns or thoughts. The judge could absolutely get around Ripple's sales of XRP because the SEC didn't go transaction by transaction applying the Howey test to each transaction. Instead, it went with what I wrote in my brief. Essentially, the SEC is applying the old but-for causation test in this case. The SEC, the SEC essentially argues, but for Ripple executives, Jed, Chris, creating XRP, XRP wouldn't exist. But for Ripple helping create a secondary market for XRP, a secondary market wouldn't exist. Look at what I wrote above. The SEC said past sales were securities. The SEC said present sales are securities. The SEC even argues if a country outside of U.S. jurisdiction declares XRP a currency, it will only be because of Ripple's efforts, even future yet unknown efforts. In other words, if El Salvador would have made XRP legal tender like it did with Bitcoin, the SEC is claiming it would all be due to Ripple's past, present, and future efforts. It is an extraordinarily all-encompassing theory, but that's not how securities laws get applied. Think of how arrogant the SEC is to claim that if a foreign country deems something legal tender, it will be a security. The way the judge could give Ripple an outright victory is simply... Excuse me, folks. Sorry about that. Let me take a sip of water here. That absolutely came out of nowhere. Anyway, sorry. Back where we were. So where was I? Oh yeah, here we go. The way the judge could give Ripple an outright victory is simply reject the SEC's sweeping claims and say you didn't prove any specific transaction. The SEC is all over the place with identifying the common enterprise. First it was Ripple. Then its experts said it was the entire XRP ecosystem, which includes the exchanges, all XRP holders, and even independent developers like Spin the Bits, which offers an alternative to on-demand liquidity. But then the SEC abandoned its so-called BS expert and didn't rely on that testimony. Instead, the SEC argued XRP represents the common enterprise, while also arguing XRP represents all of the promises and efforts made by Ripple. What this means is the SEC is essentially arguing that XRP itself meets the second and third prongs of the Howey test as a matter of law. The SEC has the burden of proof. It has failed to satisfy the second prong of Howey, and it has failed to go transaction by transaction. This is why I'm confident the SEC is not granted summary judgment in the manner they have requested. It is also why I could see the judge saying, denied and arguing the jury must decide certain issues, e.g. non-investment uses of XRP, recklessness, fair notice, etc. What some people have failed to consider is that Judge Torres could say denied to both summary judgment motions, and it goes to a jury. Until we get to read all the Rule 56 facts and read all the underlying evidence relied upon, it's near impossible for me to predict anything more. But, see, to me, that is a home run analysis. So we don't know for sure what's going to happen. Obviously, I'll always admit that. Attorney Deaton does. But in terms of, did the SEC prove its case? That's a flat out no. I'd be shocked if the judge actually ruled in favor of the SEC's motion for summary judgment. So I don't know. I'm not saying that means necessarily that Ripple gets a slam dunk win. I'm not necessarily convinced of that. But in the end, for me personally, I'm still optimistic there's a path forward for Ripple to continue operating in the United States and for XRP holders to continue to buy and sell and hold XRP if they so choose. I'm optimistic. We'll see what happens. We could get a bad ruling, but I'm just sitting here waiting. So there's the path forward. And to anybody that disagrees, totally fine. I just think it's fun and nice that as an XRP community, we can disagree with one another respectfully and just kind of share our ideas. That's exactly how it should be. People don't suddenly become your enemy because they believe something differently than you. Yet tribal humans sometimes behave differently. So this is perfectly civil and nice. People respectfully disagree. And I like it. I'm a big fan. The XRP community continues to be the best community in all of crypto. I'm not a financial advisor. You should not buy or sell anything because of anything I say, all right? That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.